My goal in this time is really not to spend too much time lecturing. I think you guys have had a tremendous amount of that. I've sat in a couple of the earlier sessions, which have sounded exceedingly enriching, actually. I wish I could have heard even more. But what I hope to do in the next while that we're together is to discuss a little bit more in depth some of the complexities having to do with the issues of political and partisan gerrymandering. To do that, though, it would help me tremendously to know a little bit more about you all. I won't ask you each to introduce yourselves, but I would like a little informal poll just so I can get a sense of the areas that you come from and what sort of level of involvement you've had with these issues before. Can you tell me how many of you all in this room are either admitted or closet lawyers? Okay, so a few of you in the room. How many of you all are then on the mathematics side? Mathematical quantitative analysis people, okay, great. And let's see, I've not covered either people in the press. Okay, no people in the press, that's interesting. Okay, an area that I haven't yet covered. Interested citizens who don't do any of those things but are good voters and are really interested to learn more. Okay, great, great. This is good. I talked to a variety. Has there anybody I have not yet named? Educators, okay. Good citizens. Any other groups? Just give me a shout out. Let's see who I haven't named. So educators. By the way, educators, high school, elementary, okay. High school, okay. Social studies, government, none of the. History and government and math, great, good. Every good mathematics person needs to start early. What's that? Politics, great, good. So I talked to a lot of these groups. I don't think I've heard a group yet that I haven't named, although this is actually the first group of mathematicians that I've spoken to primarily. As you may or may not know, I do kind of spend time in both worlds. I thought I heard some hissing all of a sudden. I'm going to assume that wasn't against mathematicians. I spend a lot of time in both worlds, in part because I'm one of those weird people who spent a lot of time studying both on the social science side to understand the analytics behind redistricting before it got cool, and then the emerging legal side. And so I find myself talking to groups that don't often understand each other, and it's really exciting to me to have met, at least over the phone, Moon, who expressed a really strong passion about this issue. And I hope it opens the door to a lot more opportunities for these different communities to speak to each other, because I think there's a great deal of potential for more learning and education on both sides of the street. And so that's my hope, at least in part, about what we can accomplish together today. I don't plan to talk for the full hour. What I'd like to do is spend probably like 40 minutes or so kind of talking about a few concepts that I think are worth thinking through as we're both on the legal side and the social science side, trying to work through some problems that courts and, frankly, decision makers on the political side are going to be thinking through, in fact, are thinking through as we speak. As you might know, even though we typically work off of a cycle of about 10 years to engage in redistricting, I know that came up today in the District Builder session, there are any number of places, many of which I spend a lot of time, that are engaged in redistricting now in response to court orders. So a lot of these questions remain live, and in fact, a lot of the sort of challenges that underlie the legal claims that started these court battles in the first place are still being worked through. And so the conversations I'm going to introduce some today and invite you all to think some about actually are questions that haven't been fully resolved. And it actually welcomes, I think, a rich and lively debate, both about what concepts mean, but also, and this may be more relevant to the mathematicians in the room, how we go about figuring out where a concept is at issue. That is, how we measure how well a state has done to accomplish a certain goal, or to put it differently, at what point is a line crossed beyond which the court should intervene. So I'll talk a little bit today. I think some of this stuff has been addressed earlier, so I won't belabor the point, but what I'll invite you all to do is slow me down if there's a point at which you want more discussion about. But what I'd like to do in any case is once we get through this, these comments that I make, I'd love to get your feedback. And as we, I think, get through about like an hour and a half, we should have more than enough time to engage pretty fully. Okay, so enough about introduction. Let me say a couple things about more specific cases that I've worked on. I don't usually talk in depth about the projects, but I can say I've worked in about half a dozen states on a variety of cases, and some of which I'll talk about later tonight on the panel, that involve challenges involving line drawing. Usually when I get called in, a party knows it's about to get hosed, or put it more bluntly, they know they're going to get screwed and they know they're going to have to go to court. And the goal is to try as best you can to make the best case you can to the majority, to set up what may be a lawsuit, and in the long term may politically be the basis on which you run an election that says, hey, the other side has really subverted the process. We need a better opportunity, a better system to allow your views as voters to be reflected. My roles have varied between consulting people in that legislative process, to serving as an expert witness, to serving as amicus counsel. And in all of those roles, though, what you see very early on is this interesting moment, as I suggested, where you realize the lawyers, while pursuing the goals that they're trained to pursue in law school — I've taught a number of them, and they are, focused on narrowing the issue to a very specific set of questions that the court can easily answer, that is on a, on or off switch. It is either on the right side of the line or it's not. And on the other hand, you've got politicians who are obviously thinking about their own futures, right? They've got actually to run in these districts no matter what happens, and they want to have a situation that's most favorable to them individually, and then ideally, if we can get that far, to the party. And often what you see in all of these settings is they can sometimes clash. And what I want to talk about is the way in which those clashes sometimes produce conundrums in the law. So, I do want to offer first one thing that I always like to say to groups, and I'm so excited, as I say, that many of you all want to get engaged in the question about reform in a number of different perspectives. What I always say is about reform, what this guy, one of my favorite characters in The Wire, always reminds us about the importance of being skeptical and questioning and careful about the concept of reform. I don't know, how many of you all watch The Wire? Anybody? Okay, good. So I'm not totally speaking Greek. Brother Muzan, right, hired contract killer, part-time philosopher, tells us something really significant in the season of The Wire where the city government gets the bright idea to knock down all of the public housing projects, right? And that goal is to get rid of the scourge of the drug trade, presumably. But what you see slightly under the surface, and what Brother Muzan spots, the moment he shows up and sees what's going on, he says, there's a little funny thing about reform. The question isn't always what intends to be sort of the thing that replaces what's being knocked down. The question is who benefits from that process. And it's usually not the target or the community that's being claimed in public. And so often you have to think carefully before pursuing a reform, one, to think carefully about whether or not a particular fix actually does all of the work it's claimed to do, but then who are the winners and losers, right? Now, that's not always obvious, but it's worth thinking carefully about. So these are my caveats to anybody that thinks about reform. Certainly pursue it, but always be careful and consider three things. First, always make sure that you're considering people. There's an inclination, and I know it, and I understand it, I've experienced it. This is often presented as a clash between titans, right? The Democrats versus the Republicans. You should know, just so that you have my biases on the table. I've sued Democrats, I've sued Republicans. My goal has been about the policy and the principle, not about the people who are running for office. They're relevant, but they're not determinative of how I think the rules ought to be applied. So always remember that this is about people and voters. They usually are brought in as a sort of tail-end consideration. But those are the interests that should be brought in first. When we talk about the idea of what a community of interest is, for example, we rarely actually engage questions about what people who live in these areas actually think. There haven't been until recently. Again, some of the sophisticated technology described in our earlier session give us a sense of what is, I think, around the corner. But we haven't traditionally in this field had an easy, accessible means of collecting views about what people think their districts sort of look like, or what the communities are that people actually readily identify on the ground. Usually that's done from the top down. The elites are looking and deciding, well, that is a community, and that's a community we ought to decide to prioritize over contending ones. Well, we're now at the space where individual communities can do that themselves, and we need to think carefully about ways of actually encouraging that and making that more accessible. Second, and this is my hobby horse, I'll tell you, it's much of my research, take race seriously. I have gotten into debates with any number of people in the academy, sometimes in the political world, about various forms of the following argument, and that is, well, look, this race thing is a thing of the past. We should be thinking in a purely colorblind fashion, and therefore any attention to race whatsoever is counterproductive, is politically, let's say, disruptive, and frankly, it can be constitutionally troubling. Those are the arguments I usually confront. Now, I think those are interesting theoretical arguments. I certainly believe there's a limit beyond which race should be considered, but I think to deny the fact that people, among all the different identities that they express and live on the ground, certainly in the place where I'm from, in the American South, to deny race as one of those features is troubling. And it's troubling because it actually reflects a number of things that go beyond politics. And so if we deny that, in my opinion, it cuts out a significant opportunity for people who have had a particular tradition of marginalization and exclusion from political representation. It prevents them from actually being able to live that out now. We've not been very long in an era where we've actually thought about race as one legitimate consideration, right? Since 1965, traditionally, we've kind of marked that. That's not been that long, certainly compared to the life of this country. It pays, I think, all of us to take account of the fact that people actually associate in schools, neighborhoods, and churches around race, among other considerations. So to deny that, it strikes me as troubling, even if it is complex. I'm not suggesting it's easy. There's no Pollyanna version of this narrative, but I think there is a very significant harm to be had for us all if we deny the fact that race informs some, if not all, of the way in which people think about their public and private lives. So respect racial identity. And then the last consideration actually is tied to the second one, and that is, look, the world is not full of bright lines. We like to think in law world that something is or is not legitimate, or that the rule is that it is either correct or it is not correct. And there are certainly cases where that's true. In the world of politics, however, what you find is that standards are usually what govern as opposed to rules. And standards are multi-factor tests that are context-specific, right, that take in a multitude of factors. Those defy simplicity, right? And what we have to do, therefore, often is think about it from the social science perspective, sort of as a sort of multivariate set of considerations, right? And when we do that, sometimes it becomes messy. Interpretation becomes significant, but that's sort of the point of discourse, right? We arrive at a conclusion based on a long discourse about what we think the data is telling us, or what we think the public as a whole is discussing. All right, enough of that. That's my sermonette for the day, but now let's get into some of the weeds on the law. So I think, correct me if I'm wrong, I missed the earlier discussion today and yesterday about the sort of legal landscape, but I got the sense that both of those presentations gave you a very general discourse about where the law is, that is on race, gerrymandering, and partisan gerrymandering. Is that fair? I don't want to retread ground that has been covered. So let me just jump right to what I think are the complexities that are left. And it's the complexities, as I suggested earlier, that really ground some of the challenges that I think social scientists, thoughtful citizens, people who are not lawyers can actually make an interesting contribution. So I'm going to just kind of race through it, but I'm going to focus in on what I think the conundrums are. So just to remind you, when we talk about racial gerrymandering, right, the sort of court has delivered a sort of jurisprudence from the 14th Amendment since about the 1990s, back when I was here in college in this area, that race can't be the predominant motive in a legislature drawing districts. It can't predominate over other traditional districting principles. Judges in practice are looking through the process to determine whether or not there were some things that were abnormal, or the results of that process led to things that are bizarre in terms of their shape. So when you get districts that look strange, when you get a process that doesn't fit the typical narrative of how legislation, in particular redistricting legislation, gets adopted, the court's going to find a need to look more carefully. Usually in this process, though, what you hear legislators who want to defend the districts that are being challenged, they always will tell you, almost always, certainly since the 1990s, say, we didn't have any consideration of race at all, right? Race had nothing to do with what we did. You hear this in a lot of different contexts, but there's a problem here. The problem is we actually have a federal law that demands attention to race to some degree, right? While the rules that I was describing and that you already have heard about with racial gerrymandering is you can't take race too much into account. The rules that say that you actually have to assure that you aren't ignoring potential harms that existing racial groups have in redistricting. So again, it's probably been described to you at this point. The goal of redistricting in this context is to draw it just so that you take race enough into account. But that clashes with the potential defense that a lot of people want to offer is, well, we didn't take race at all into account. I literally heard this just now in the state of Alabama, where the legislature, in trying to correct a plan that was declared unconstitutional by the court, a plan that took race too much into account, the line drawer, with a straight face, says to the court, well, we've drawn this new map based on the old map, but we didn't take into account at all of race. Now, you don't have to be a lawyer to think of the logical problem here. If a plan that took race too much into account is the basis of a plan that you now say takes race not at all into account, it's kind of a hard sell. But this is one of the challenges that we have. How do we respect the anti-discrimination claims that say we can't discriminate on the basis of race, and therefore we need to make sure that the potential effects treat racial groups that have had a tradition of being excluded fairly, but at the same time we don't let race override everything else? How do we do that? And usually where you find the complexity further exaggerated is in the South. Party and race are inherently, in a lot of places, linked. You probably have heard this discussion already, so I won't belabor the point. But partly due to our history, we have a pretty strong bifurcation of the political identities that has sort of flipped since the 1960s, where African Americans are, in fact, pretty much across the board in this country, the most easily identifiable Democratic group that's out there, right? White Southerners in particular are a little bit more mixed, but certainly more than about 60 to 70% of the time you identify a white person, chances are you will find a person who identifies as a Republican. Now you throw that in a pot and call it a state, you've got a pretty interesting politics where race doesn't totally define whether you're a Democrat or a Republican, but it can do so. It's a pretty reliable predictor. And it becomes further troubled when race defines how you draw the districts. Because if you're drawing districts so that, say, you identify readily African American majority districts, you've also drawn Democratic districts. So how do we figure out a rule that establishes the proper extent to which we could involve race into the drawing of districts? That's really the hard challenge, particularly where we know that voters, at least to date, have naturally identified, at least in the current era, using race where African Americans are very heavily Democratic and whites not as much, but pretty strongly tend in the South towards the Republican Party. Now, one answer, just to give you previews of coming events, is, well, how can we influence the way people make their choices, right? If we want to have a more sort of robust politics, maybe black voters should start to find Republican candidates to support. And the response to that is, well, if there were Republican people who actually would go after black voters, maybe so, right? But that's a sort of hamster wheel that we don't have to run on today, but just know that that's out there. All right, so we've got this conundrum in race, again, where we see a world where we've got an attention to race, but a limit out there in the law that says, well, don't take race too much into account. Partisan gerrymandering is a little bit different. I should say, by comparison, race gerrymandering has been heavily litigated. Again, I told you, there are cases sitting out there right now that are in flux. In fact, I'm going to go to North Carolina probably in the next couple of weeks to deal with that problem. But these are cases that have gone on pretty much from pillar to post, from the beginning of the decade until the end of the decade, just in time for the new process to go forward. And courts have been pretty active in litigating in this area, or judging litigation in this area. By comparison, partisan gerrymandering, not so much, right? The court gives us a fairly relaxed standard, partly because they disfavor engaging in rules that look partisan, right? You've heard that stuff before. This has not been the Supreme Court statement, but one of the statements that I often teach in election law comes from the Ninth Circuit, which the Supreme Court affirmed, which is not quite embracing the full analysis, but it's law that's out there and that's relevant. A Ninth Circuit case that involved Republicans, oddly enough, in the 1980s, who made an argument that the Democratic legislature basically undercut any opportunity that they had for serious representation in Congress. They lost the claim. And the Ninth Circuit, in reviewing that claim, made the argument that, well, you know, we know that you probably could have gotten more seats, but who are we to tell you how many more you could have gotten? You've heard this argument before. What's fascinating is they sort of hint at a standard that says, well, the only way in which we think the court should be involved, says the reviewing court in this case, is where the party like you who's complaining is totally wiped out at the polls. You have zero representation. Well, think of the practical truth of the case where that's true, ever. Right? There's always going to be one seat that's out there. And in this case that I'm describing out of California, the argument of the court was, well, wait a minute, we're not even going to just look at the congressional seats that you're challenging. We're going to say that, well, even if you don't have any congressional seats, it's possible that your party can be represented at the state level. Or in fact, even at the federal level, where you've got, say, a president of the United States who happens to be from California and a member of your party, that's some evidence that you're not totally wiped out. So as a practical matter, right, the absolute ability of a party to actually challenge this kind of standard successfully is kind of difficult because the purpose of the gerrymander, you've seen this already, is always to reserve at least one seat, right? You got to put these people who are pesky voters who don't support your majority party somewhere. So why not oversaturate them in at least one or a few districts, and you can just sort of shunt them away. Makes the world safe for the rest of us, right? So the challenge as a practical matter, at least up to now, has been rather unrealistic for plaintiffs trying to challenge partisan gerrymandering. And you can hopefully see some of the reasons why, at least to defend the courts for a minute, why this might be a little bit problematic for them to try to wade into, right? One, competition is sort of a feature of why we think politics works in our country, right? We think as long as we have, right, market A that has a Democrat and Republican in it fighting each other for domination, that maybe somehow the public gets a chance to choose, and as a result of that, right, the right answer over time kind of comes about where that representative interest is sort of, fully realized. That even if the Republican doesn't win in a heavily Republican district this time, there have to be 2 or 3 times more where, on average, right, the right answer comes about. Well, obviously, we're getting to the point now where there's a tremendous amount of research that suggests that we're better at crafting districts that are predictably, indeed reliably, ones that produce a certain outcome. This prediction, at least in the 1980s, might now be a question that the Supreme Court wants to address. As I said here, the last point in this is, at least from the 1990s, we were left with a point where the court was at least on the fence about whether or not the law of partisan gerrymandering was a viable area that plaintiffs could mine. That is, whether you could go to court and challenge a state that had drawn districts having violated a standard called partisan gerrymandering. The court says, well, okay, we think that exists, but we can't quite tell you a workable standard to determine whether or not that rule has been violated. This is sort of Justice Kennedy's sort of contribution to the I guess we can call it the standards in partisan gerrymandering, in that he hasn't given us a standard. In fact, he was excoriated the last time he issued an opinion out of Pennsylvania for actually doing just that. That the typical approach of the court is to say whether or not a plaintiff wins or loses, but to tell us why the plaintiff wins or loses, and for future plaintiffs, what one has to do in order to win. And Justice Kennedy hasn't told us that. And as you probably know, in October or so, the Supreme Court is going to find once again an opportunity to consider whether or not there is such a standard out there to determine whether or not a state that uses partisanship to drive its decisions about how districts get drawn violates some part of the Constitution. Now, just as a preview of coming events, this is now my own opinion on the matter. Justice Kennedy has told us, at least as a hint, that he can't tell us a standard, but he seemed to believe that it's possible that the First Amendment gives us a theory for under sort of idea of association, we think, how a partisan gerrymander might actually undercut sort of core fundamental values. Now, most of you all know a little bit about the First Amendment, if not a ton about it. And the concept actually goes back in some ways to what I suggested earlier, this idea about a party being totally eradicated. If it's impossible for a party to do that basic thing that we think parties do, which is bundle people with like values together to support candidates, then Kennedy seems to suggest, well, maybe that's a place where we say the court should get involved. But how do we measure that? Is it ever the case that a party is totally unable to do that kind of work? And to what extent are we going to say that that's the only way in which a party can be active, right? Parties do more than that, right? Parties raise money. Parties issue press releases, right? Parties do a lot of organizing outside of the electoral realm. So the challenge, I think, is going to be, at least through a First Amendment lens, how do you articulate to Justice Kennedy a workable standard? Now, the claim that's being presented to the court lies more in the 14th Amendment side of things. Just know that that's out there. But my point in saying all of this is the conundrum here is that we think competition is a good thing, but eventually, if the courts have to be involved, they are in some ways going to regulate competition. Now, we do that in the antitrust world, right? We don't allow one company to gobble up so much of a market that they get to control the prices and the supply available. But in this case, it's a hard call to ask a court, at least from their perspective, it's a hard call to ask a court to intervene in a way that would disrupt the normal competition that exists between Democrats and Republicans. And the hard question is, well, if they don't do it, then who does? All right, so those are the sort of existing conundrums. You've got on one hand, the court heavily regulating an area where they're saying, well, not too hot, not too cold. On the other side of the street, you've got the court being asked to think about partisan gerrymandering, but they're doing it in a way that suggests that they have to get involved in a place where courts, which are unelected, remember, are really loath to go in and articulate a standard for fear of saying, well, if we do it in any particular way, we may basically consign either the Democrats or the Republicans to a standard that they can't easily fulfill. And that fundamentally shifts the sort of balance between each of those parties in the party competition of election. I don't know what the correct answer to that is, but know that those conundrums are out there. And that's really the hard challenge throughout all of this. Now, I'm not going to give you any silver bullet answers to any of this stuff right now. What I'm going to offer you, though, are some thoughts about what I think, at least in the place of redistricting, can get us a little farther along the path to trying to develop some of these answers. I would normally spend a little time sermonizing about stuff I think each of these communities could learn from. I'm going to skip that right now, in part because I'm going to do that in a panel later tonight. But you know what? If you want to hear more of my little sermonette on what I think academics, courts, and lawyers each could do better, I'm happy to talk about that in the questions. But I promise I'll bring that up a little bit later. What I want to get to now, though, are solutions, at least, again, hints at solutions. And to do that, I wanted to at least present what I think on the table at present represents sort of the way in which most reform proposals are being framed. And I think these are good, but I want to at least group them for you to be on the lookout for. The first set of reform ideas fall under this idea of prohibited considerations. That is, right, a world in which we're not going to tell you exactly how to draw districts, but what we're going to tell you is what you can't do when you think about drawing districts, right? So there are going to be certain places, California among them, right, which has led the way in some ways, in the recent move towards independent redistricting. They created a citizens commission. I take it by now you've heard about the California system, so I won't recount that. Anybody from California? Okay, one, gotcha. Okay, two. All right, a little underrepresented for the rest of the population, but that's good that you're here. So what California does, though, is set up an independent commission which takes the decision-making away from the legislature, right? That's a structural consideration. But what they also do, and this is why I bring it up, is to say there are two things that we won't allow you to do. You can do a lot of different things, but two things they won't allow you to do are, one, take partisan data, that is past voting practices, into account in drawing districts, so that when I draw a line around a given neighborhood, I can't know, at least the line drawers officially can't know, whether they have in the last, say, 4 or 5 election cycles voted heavily Democratic or heavily Republican. What I also can't know is where the incumbents live. Now, you know enough about this to know that usually everybody knows where the incumbents live, and they're very keen, right, because they don't want to pick a fight if they don't have to. But note what that does, right? It pushes, on the positive side, a sort of new way of thinking about, well, what does identity mean in this context? We have to now search for different models for defining identity. And maybe it invites the public to give us new conceptions of what identity means. What it also does is makes a lot of incumbents very jumpy because, right, they don't know what's going to happen. An incumbent might be matched up with 1 or 2 other opponents that are incumbents. An existing incumbent might be moved out of the existing district where they happen to live. And that obviously creates a lot of problems. Now, I will give you the other side of this, because I don't mean to suggest that, California is the best thing ever. It's got good weather right about now, but that's another story. With respect to the question about incumbency, though, I've told you that the line drawers can't know any of that information. You, the public, certainly can. And what is kind of a challenge is figuring out how to wall off what you know in the public from what I know as a line drawer. Because what may happen, and this typically happens, right? You tell me there's a prohibited consideration. I tell you everything that is great about this district, except the one thing that actually made me draw this district in the first place. So, in fact, some of the criticism of this system is, well, if you want public feedback, you can't stop the public from thinking about a variety of different considerations. On the other hand, there's still some benefit in saying, well, you can say whatever you want, but in my drawing a final map, I've got to take into account just those things that we collectively on the line drawing commission find important. So fine, make your arguments about all this other stuff, but they better be persuasive on their own terms. And under the law, we more or less allow that, right? As long as we don't have but for causation, right? But for the fact that you were interested in protecting this incumbent, you wouldn't have favored this plan. Well, as long as there are other reasons why you would have favored the plan other than the incumbent protection, we might all find, comfort in the fact that we arrived at this for sort of neutral, let's say non-prohibited reasons. All right, so that's one answer. Another answer, new structures. Now, I mentioned the California example already. Here's another. So suppose we don't take the legislature out entirely. And let's suppose we also say, this is another of my hobby horses, I'm a lawyer and I teach lawyers. I like lawyers getting work, but I don't necessarily love litigation. I don't like litigation on its own terms because it's costly. And it costs, yes, we get paid, but it also costs the taxpayers money. And when the state gets sued and the state loses, little known fact, the state pays its own fees. The state pays the fees of the winner too. And if you think about the cost of doing that in a plan that everybody knows is faulty, but the politicians want because they're the majority and they want to give their shot to get what they can, it creates a rather inefficient, one, but ultimately silly system. And so it would save us all a lot of time and trouble if we had, let's say, a first run at considering whether or not the plan that's been adopted is legal or has a shot at being legal. What the state of Florida has done in answer to this is to set up a system whereby the state legislature draws the maps. It is given a set of considerations, but it is then immediately passed to the court for review. No need for a lawsuit. In fact, the plan is not implemented until the court has passed on it. And at least in its first iteration this cycle, the Florida Supreme Court actually did send elements of the maps that were adopted back to the legislature for consideration. And in doing so, it gave specific direction. Its view was that on certain criteria, certain numbers of those districts were not in keeping with what they understand the structures to the principles to direct in the case. What this prevented, if you think about by comparison, this prevented plaintiffs from having to go to court and initiate a lawsuit. It also stopped another important feature of this whole process, which is time. Okay, it didn't really stop time, but it did stop election time. And by that I mean this. Elections are the trains that always run on time, right? That is, there's always going to be an election. Asterisk, sometimes not, but very rarely. Judges won't stop an election from happening. What happens if you know that there's a patently unconstitutional map that is actually in litigation and it's a month or 2 months before an election? That election happens even under a map that might be later found unconstitutional. And if you can see what the potential harm is from that, right? An illegal map producing a legislature that might be unrepresentative, they're fully empowered to pass laws as much as they want. There's no court that's likely going to tell them, we forbid you, you are not going to be permitted to pass any legislation until we've gotten this adopted. That's way beyond what anybody would say the power of the court is. The challenge, therefore, is avoided when you have the court, at least in this case a state court, review in an early instance the legitimacy of a plan before the plan gets adopted. Now, we have a version of this, or at least had a version of this, under the Voting Rights Act called preclearance that essentially did the same thing, that was eliminated in 2013 by the Supreme Court of the United States, but nothing prevents a state from adopting a measure like that. on its own, using its state court system. So again, it's a way of assuring that the public as a whole understands that the legislature has done its homework and tried to comply with the rules, and to the extent that they've fallen short, the court gets the opportunity to tell the legislature, look, we're not going to tell you exactly what to do to remedy this, but we are going to tell you that there are problems associated with this map in these particular ways that don't comply with the following enumerated principles as we understand them. So feel free to go back, redo the work, and send it back, and we'll take a look. The final example, a special measure. This is actually something that sometimes gets done at the local level that actually gets the public more engaged. There is a rule at times to have a line drawing process, I think it actually was discussed today, explicitly involve public comment. Bless you. And the public comment actually reminds the legislature that, or whoever the line drawing authority is, that its job is to make sure that once it draws these lines, it's got to actually reflect the interests that have been expressed through the process. So one easy way of doing it, and you see this sometimes, is that the legislature or the deciding body has to draw the map and explain its reasoning. That is, go back to the evidence as an administrative agency might and show the ways in which it complies with or, contrasts with the existing evidence that's been put on the record. You don't necessarily have to follow everything that was done, but to the extent that you're not going to do it, say you're not doing it and say why you're not going to do it. Now, that's not necessarily a legal answer, but it does give these elected members some sense of accountability and transparency. And that's actually, to me, an important feature, because none of this works, to be frank, if the public doesn't hold the people who draw these lines accountable, right? I mean, lawyers can go to court, the judges can give you a very strong opinion, but at the end of this entire process, there's got to be this thing we call an election. And if people aren't held to account, either successfully giving them credit for what they did or exercising some penalty for not complying with what the public's interests are, then the point of this all is sort of a ruse. Again, people will get paid from it, but in terms of the public's benefit, I'm not sure that there's much to be had. All right, so last comments I need to make, and then I'll open it up for questions. My general principles, as I say, I don't believe there's any one fix that's going to cure everything. I do believe the more people that get involved and interested in this, that's good. But I do think that whatever anybody that talks about reform usually will call me about asking my sort of, up or down gladiator vote on a particular fix. And to be fair, I do think some work in certain contexts better than others. But I don't think that there's a one cure-all way of solving this problem throughout the entire country. But I do think that there are principles that you should at least consider when thinking about the efficacy of any one of these fixes. So the first one is, my view is always, any fix that we think about needs to be data-driven. We need to think about facts, right? Not fake facts, but facts. Now, I say this because there are extreme cases, right, where the line drawing authority says, we want what we want and that's it. We got the votes, period, stop. I don't care what you want. Right? Those are easy cases, right? That's bad. We don't think that's really public-minded, very democratic. But what about the following case? Suppose I were to tell you that I've got to decide, let's say, how many districts I'm going to draw in a state that has been heavily disfavored in the past. Or let's say districts that have had not a lot of growth in the past, but all of a sudden has had in the last cycle ridiculous amounts of growth. And it's been growth from people outside of the state. They come with a particular viewpoint, and so we want to make sure that we have districts that reflect that viewpoint, whatever that is. Now, I could decide how many districts I want to draw. I could do it arithmetically. I could do it based on the viewpoints of the people who are elected, right? They have a sense of who's there, and they talk to people. Now, if I have to choose between those two, I've got a preference. You might choose differently, and that's okay. What I want to suggest to you is, though, whatever view you take on the evidence, whether it's anecdotal from individuals or aggregate data-driven, you need to actually be explicit about what those reasons are. As I say here, anecdotal evidence, I think, ought to be disfavored, but it doesn't mean that they shouldn't have any relevance at all. I've been thinking in particular about a case where there's a discussion about how many districts should have a percentage of, let's say, African Americans in it. to comply with some considerations to make sure that African Americans in a particular part of the state are not unfairly represented. They have a fair shot at, electing a preferred candidate if they want to. Well, you could do that arithmetically. I look at past elections and come up with roughly an estimate of what that percentage ought to be within a range. What a couple of cases we've seen out of Georgia and Alabama involved, however, was a line drawer going to the person who happened to be from that area and saying, well, what do you think? Again, not totally irrelevant, but less relevant than evidence of past performance. And I think one of those challenges is thinking about, for the court's perspective, what is it that we're asking legislators to do when they consider whether or not the evidence that they take in to determine these questions has merit, is consistent, is this kind of stuff that you can put against objective testing. Because if you don't use that, let me just sort of play this out. If you don't do that, it's everybody's opinion, right? And everybody's got one of those. How do I know that your opinion isn't informed by your interest in being reelected if you're an elected official? I might do a little bit better if I ask the public who happens to be from that area, well, what do you all think? I could run a poll. Well, that's helpful. But we need to have metrics that give us a better handle on objectively, small o, what's going on out there that gives us a handle on how we ought to draw districts, whether it's, again, a percentage, number of districts that's drawn, et cetera. Because otherwise you give the line drawer a lot more discretion, and I think in a dangerous way, for deciding what it wants to accomplish without seriously thinking about what's going on the ground. All right, I've said enough of that. Here's a second. Consistency, right? This is a shocker. You have a rule, you need to apply the rule across the board. What you often see in court cases is this. We had a series of considerations we had to take into account. It's a very complex process. We don't quite know exactly how it worked out in any given district, but know that we took it all into account, right? I don't know if there are any number of administrative law cases that are this way as well, right? I'm not very happy with the share of the goods that I was given. I challenged the decision maker's formula for determining my share. The decision maker says, oh, it's a complex formula. Don't worry your pretty head about it. There's just so much there. But somewhere lost in the details is the ability of anybody to look over the shoulder of the decision maker and make an assessment. Did you do what you said you were going to do? Now, in this world, I don't say that it's impossible to come up with an exception to the rule. Of course, the world is complex. I said that earlier. But if we're going to have exceptions, they should be exceptional. And the state should have to, I think, should be able to articulate the whys of what it did and what it didn't do. And what you see in a lot of these cases, now and again, the state will not be all that smart and put things on the record that suggests, well, okay, they said they were doing this rule, they were using this rule in a consistent manner, but look, there are 5 or 10 or 20 ways in which they didn't do that. They could have done it to be consistent, but they haven't. States are getting smarter about that, but it's important to think about consistency in applying any of these rules. All right, last point, transparency. And I've talked about this already, I won't belabor this point, but at the close of all of this, we should be learning something, right? Yes, there are going to be winners and losers. There are going to be people who are excited and people who are maybe in despair about any line drawing process. That's just a fact of life. That's true. But one of the things that I think you should always judge any process, whether it's a board game or, for that matter, a redistricting process, is the extent to which you're willing to play the game again, right? That is, the person who loses, doesn't get all that they want, has to feel confident enough in the process that they can, on the next run, if they do some adjustments, if they work harder, if they get more voters, that they can have a shot at getting a better shake out of the process, that they get a better share of the goods that are out there. Part of that rests on transparency. I've got to know why I didn't do as well as I did this time. Or I have to know what the considerations are that the line drawers are taking into account, how they're balancing things out. To the extent that you keep this stuff veiled, right, that's exactly where the devil lives, right? Because I can make a decision in any of these circumstances about, sneaking in considerations to help Representative Farmer Joe or Banker Tim, right? And dress that up in the pretext of, well, we're following the rules, we're following objective considerations as much as possible. But this does the work also of allowing courts to more easily ferret out the places where it can teach the rest of us in the public, but the legislature in particular, about how to do their job more effectively. So my view in all of this is, look, this is all enhancing a procedure that helps right? Democrats and Republicans do their jobs in line drawing or as independent commissions, but it really helps us all collectively be more effective interveners in this process to tell the legislature what we want. We've got 10 years, every time a district is drawn, for that matter, to collectively organize and figure out what it is we want out of a district map, who our allies are, what our issues are, how we actually articulate our message. One way that we do that most effectively is by knowing what the rules of the game are and what the decision maker is going to take most into account. So my goal in raising these is essentially to say, look, I don't believe that there's any one fix to any of this stuff, but what I do believe is that if we take these concerns into account, we can at least know what we're getting into. We can at least tweak a proposal so that the public can have a fair shot at engaging. And that if we have to go to court, we do it in a way that doesn't sort of have us chasing the hamster wheel around and get to an answer that actually allows us to have elections that are legitimate, that get more people involved in voting. So that's the sermonette. I would love to hear your feedback or talk about any of the other stuff that I didn't talk about before. Yes, sir. So the question was about consistency. Well, we have instances where you're right to say we've got lawsuits that go on endlessly. And in the interim, you can have a legislature redrawing plans. How can you be consistent in a world that's ever changing? The answer is it's messy. I'm not suggesting that it's going to be perfect level of comparison. As I said, even taking, let's say, the clean case, where you have, let's say, state of Texas, a state that's seen a tremendous amount of growth and is about to see even more in the next census. From census to census, we're seeing a fundamentally different state, right? And we will probably for the next 2 or 3 cycles. In some ways, it's challenging to think through exactly the same population balances, let's say in the 1990s as in the 2000s. That population is quite different. But what we can say something about is this. The state has had a practice of favoring certain areas of the state in a certain way, right? So cities get a certain amount of representation, not quantified, but we always give the Panhandle a seat. Panhandle isn't terribly populated, but if we all of a sudden choose not to do that in this iteration, that's peculiar, not unjustified, potentially, but we need to offer a justification for doing it. Or by comparison, let's say we haven't had a lot of growth. The example I gave you earlier, we haven't, in fact, it comes in some ways from Texas. We have an area that hasn't had a tremendous amount of growth. All of a sudden, in this new iteration we do, we've got to decide now how to represent that growth in these new maps. Well, one way we could do it, the easiest way, frankly, is to just situate a number of seats in that region. Now, to do it might be justified because we have an identifiable group. In the state of Texas, the argument was Latinos, right? Latinos were responsible for, I think it was like close to 75% of the growth in the last census cycle in the state of Texas. What you would have expected is the areas where there is the heaviest growth in the Latino community would get an appreciably large number of districts compared to the rest of the state. That didn't happen there. So this question about consistency, if we favor growth versus disfavor loss in population, can be a problem. It doesn't get us all of the way, but there are places from cycle to cycle that we can make some observations about what the state's practices have been. So you're right, though. It gets more complicated when, let's say, the state legislature redraws districts in the midst of the decade. And in that case, by the way, it's interesting because it raises yet another of these problems. Suppose you are trying to determine how to draw districts in the middle of the decade. In fact, I think the state of Georgia just now did it in this last year. We're now in 2017, so right closer to the end of the cycle than the beginning. Georgia, it may be surprised, maybe most of you all know this, has had a lot of growth. What are the numbers that Georgia ought to use to draw its districts? Because we know all the districts, at least on paper, have to be equal in terms of their population, right? Should it use the district numbers that were derived at the census of 2010, which we know are inaccurate, right? Or should we invoke a rule that says we should be looking at the number of people that exist in this state right now? Now, there's not a federal census that does that. It only happens once every 10 years. How do we do it? who do we count? Now, you could imagine a very different answer depending on whether you use the old census numbers of 2010 or come up with some standard to estimate what the numbers are right now. How do we, I don't know which way consistency takes us, but you're right, that sort of continued review of the map as changes occur kind of raise hard questions. But I just want to at least signal it. But there's more to say about it, but those are just two examples. Let's go to this side of the room. Yes, sir.
In Virginia, 20% of our population is African American. 12.5% of our general is a pretty big drop off there. Is that first question? Is that similar in other southern states? And the second question, I get this a lot. I don't have a good answer for it, but for people who are skeptical of the Voting Rights Act and its impact, if you just got rid of Section 2 and you did race neutral, I almost don't imagine a world where you could do fewer than 12.5%. I think you have no place to go with that.
So, good question. So the questions were about the question of the disparity, if you will, between the population percentage of African Americans, and it's true, to some degree for other groups, and their representation within the elected General Assembly. Now, I assume there's some political scientists in the room. Yeah, I see one. Some closeted. Oh, okay, some more in the back want to admit it. Fair enough. And so there is, right, a thriving literature in political science about this topic. And the question is sort of, what does representation mean, right? So you've offered us a fairly straightforward measure of representation, that if you have a percentage in the population, you would expect something close to, right, the percentage of the population in the legislature. So the answer to your question, to get to the point about how common that is, it varies. And it varies for a number of reasons. And it goes to some of the theoretical challenges that you see a lot in political science. So let's take North Carolina, your neighbor to the south, for example. It actually has a similar gap, but not as huge a gap. But in North Carolina, the part of the reason is that there are majority black legislative seats that have elected white members, white Democrats in particular. Now, you could say, well, how do you look at that white elected member? Right? You could say, if you would take a racially essentialist form of argument, that, well, that person doesn't represent the community in the same way that an elected black person would. The law takes a different approach, and I want to emphasize this. The law takes a different approach because it says that we don't look at sort of the question about identity in that form. We instead look at the question as to whether or not the voters have chosen a person that reflects their interests, whatever that is. It could be a black person, it could be a white person, but we're going to take that as our standard. Now, this is a messy part of Section 2 law, and I want to get to that point too in a moment. But you could make the argument that the election of whoever reflects their interest, and it doesn't necessarily mean forever and always that it'll be a white person or a black person in that position. So to the extent that you see the drop-off, it's not always, due to, let's say, a loss or a failure of black political efficacy, if you will. Alabama, by comparison, actually has pretty close to perfect equity between population and elected percentages. But here's the interesting challenge. Alabama right now, and again, African Americans are Democrats, like upwards of 90%. Out of about 33 elected members of the House of Representatives in Alabama, there is a grand total of about 4 whites. 4 white Democrats, the rest are all black Democrats. Now, they collectively are a minority, in fact, a super minority in a Republican legislature. So it limits the extent to which they can do very much procedurally, let alone substantively. And part of that, just to kind of drive the point back to an earlier view I've expressed, is due to a map that was heavily racially gerrymandered by Republicans. Now, this gets me to the point about Section 2. There are people who will tell you, look, we've gotten rid of Section 5, Section 2 has outlived its usefulness, and even from a, quote, liberal or democratic perspective, we think it's not helpful to the party to have this concentration on race because it allows Republicans to warehouse African Americans unnecessarily. And my own view on this is I think Section 2 still does a lot of work, and I don't think Section 2 has been fairly applied by Republicans, which shouldn't shock you because Republicans as a party, just on its own terms, You won't find many other places, I dare you to find me another place, where you see Republican argument ask for the most robust form of federal intervention with a race-conscious remedy. You'll never do it. I'll buy you dinner if you do. This is one place where they do. And they've totally done it in a fairly let's say, dishonest manner. They've not been as straightforward about the application of the law, but they've done it in a means-oriented way. Not saying that Republicans are the most horrible people on the planet in redistricting world. Democrats do a lot of shenanigans too. But in this instance, the use of Section 2 is really troubling because it is not just about a political tool. Well, it's being used that way, but it has serious racial effects. Because what it means is, in places like North Carolina, it has utterly undercut the ability of white voters to select black candidates. And if you think about the experience of politics in this country, part of our challenge has been that we haven't seen identity, the ability to find shared political viewpoints and goals, regardless of whether we come from a largely black or white or Latino community. We need to have spaces where that's true. But at the same time, we have to recognize that until about 1980, 1990, in the court intervention, left to its own devices, in the South, outside of big cities, you didn't get non-white elected members of Congress or these state houses. So there's work that Section 2 has done to be very helpful in improving political opportunity for African Americans. The challenge has always been in its interpretation. And frankly, I'll just add one layer to this before we get to just the Democratic and Republican problems in this. The court hasn't been very clear about how to apply Section 2 consistently. If we had consistency, to take another principle back, if we had more consistency in the way that Section 2 had been interpreted and enforced in the courts, what we'd have is a very clear standard for the legislatures to go about doing their business. But in the space that there's sort of some lack of clarity, the party races in and finds the most favorable interpretation to advantage itself electorally, and that becomes the real challenge. All right, that was a lot, but you hit one of my serious points. Yes, ma'am. Thank you.
From that perspective, those working groups together that there's some learning.
Great, thank you. So nomenclature question, an important one. This is one of the ones that just drove me nuts back, when I started in this area, because it has evolved. So you're right, the present state of that nomenclature, what does it mean to have a district that intends to provide greater representation for previously marginalized groups? Okay, that's a mouthful. How do we put that in a very simple phrase? We started with this phrase, minority majority. And that actually was borrowed in part, as it turns out, from the education literature, busing, school busing. A district that had a majority of a non-white group being bused to an area of a majority of white educational institutions for the purpose of balancing things out. That becomes problematic because, of course, demographics shift. It also becomes problematic because what majority and minority means is terribly confusing. That has evolved, and it has evolved for a number of reasons. One, because we have areas where there is no single group that is a majority, and you can have two non-white groups occupying the same space, right? Shout out to Los Angeles. And, who gets the title minority? What we've determined, and this is now, I'm going to say, this is my interpretation of it. There's no sort of, grand edict that is issued on the topic. But what the sort of dominant literature, at least in the law, uses now is what's described as a minority opportunity district. Because the idea behind the districts that I described earlier, at first was to give, these groups a chance to elect a candidate. Now, again, the candidate doesn't necessarily have to be of a particular racial group, but it has to be, we presume, the expressed interests of the voters who live there in determining who shall and shall not be their representative. So minority opportunity is the way in which it's been described, but that creates yet another problem, right? Do we talk about majorities anymore, right? Does a district that gives a minority group an opportunity have to be 50% or more? That's a whole different lecture, but I'll give you the short version of it. We've got an area of there's an area of the world in which political scientists will tell you, and as a practical matter, it's true, right? You don't necessarily have to be a majority of your own group to be effective in political campaigns, in part because you partner with other groups. Now, there is theoretically a way to use that scenario within the category of minority opportunity. We don't do that. What most people will say, practically speaking, is that that looks like what we call a coalition district. Now, again, I'm not saying everybody does this. Some people conflate all of that. But what the Supreme Court said in a case in, I think it was now about 2014, no, actually it was prior to 2010, but it was a case that came out of North Carolina that Justice Kennedy wrote, and he said, well, when we're thinking about districts that are created pursuant to Section 2 of the Voting Rights Act to assure that minority groups have the ability to elect candidates, we are going to say that Section 2 requires you to find a majority of those people in a group before you can create such a district. That is to say, we don't think that federal law privileges the creation of a coalition district, something less than 50%, as a remedy to a potential violation. Now, it gets more complicated than that, but suffice to say that that decision itself is what led to the craziness that has happened in 2010. Because some people will say, well, if Justice Kennedy is telling us we have to create majority districts of a racial group to make sure that we're not discriminating against that racial group, then draw as many of those majority districts as you can. But note what that means in practice. A lot of these districts, like the one I described in North Carolina, where less than a majority of African Americans were effective at partnering with white voters to elect a white or a black candidate, and likewise, a case where there's a majority of black voters who choose to elect a white candidate. All of them, and people are happy with these members. I heard this, I went and found out. I wasn't sure that it was real on the ground, it is. But in those instances, a hard and fast bright line rule that says if you're going to be compliant with Section 2, you have to draw a majority of these voters in a district, totally destroys each of those possibilities, does it not? And that raises a big sort of societal question, really, for all of us. Now, this is getting back to the big we, the citizens of this country. What do we think our goal ought to be in this project? We'd like to think, I think, that we don't want to always have to resort to Section 2. I'm not asking the question of whether or not Section 2 ought to exist, but we shouldn't have to all rely on Section 2 just to get a fair shake at electing candidates. But is the route to get there forcing the drawing of districts whether or not the people on the ground actually show that they're needed? Or should we have a more nuanced approach where we look at the facts on the ground and determine how to utilize Section 2? And that's really the question, I think, that underlies sort of a lot of the challenge of using majority or something else. But again, the nomenclature these days is minority opportunity. It is talking about racial. Yeah. Yeah. No, that's fair. And we can talk more about it. I'll just say for now, I want to get to more questions, but for now, I think it is fair to say that that is one example where many critical race theory and in the law, many of those critics would look at this as one example of how language can kind of cabin in. It can take an existing framework and sort of prevent us from thinking about, the way in which the world is changing and the way in which, in fact, state to state, there will be very soon, a group of people who do not look white who represent a majority of the population. So what does that mean to call anybody a minority? So it's a fair point. I take it. Let's go on this side of the room. Yes, sir.
What can you say about the policy sense, the legal sense, the relevance of interstate comparisons? So, for example, at Whitford, both sides presented evidence where they compared the Wisconsin plan to other states. So the plaintiffs say, look at the efficiency gap compared to the efficiency gap of 724 different districting plans throughout the last 40 years in the states. The defense says, look at changes in partisan composition and distribution in Texas and Virginia. The same thing's happening now. As I read both the opinion and the dissent, they sort of pick and choose and they say, hey, this is Wisconsin, we're all special cheese plates here. We don't want to hear about other states because, and fairly, political geography is different. I mean, you talked earlier about in the South, in certain racial polarization, different stuff. And yet, it seems absurd to me to say, look, we're only going to look at Wisconsin, don't tell me about Minnesota. It's completely different in there. So how does that play out? And how should it play out?
Well, so you're absolutely right. Another complex question. How do we think about interstate comparisons? And you see people, again, this is one of the things that I think lawyers should do less of and to be thinking more carefully about. Because lawyers are using this, as we teach lawyers to do, right, in a strategically competitive way, right? So they want to win the argument, and the way to win an argument is to use evidence that's most helpful to you. So let me not for the moment heavily criticize lawyers before I go and criticize lawyers. But you're right to say that if we're actually running a social science experiment, let me go back to what political scientists do, right? We surely would take in evidence that might be relevant. We'd have to think about how we weight the evidence. Right? And in this case, I think this is where this is the world of comparative politics, right? Those of us who, do it, think there's relevance, but critics of comparative politics will say, well, how do we know that we're thinking about apples and apples, right? How do we know that a state that happens to be, one pushback I got about comparing the United States of America and its election system to, say, the election system of South Africa? Are they comparative to each other? Well, they can be, but for what purposes is really the question. But there are people who say, well, we should never compare, right? We do that in the law as well, comparative law. Some people who think the United States is an exceptional case and it should not be compared with anybody else. And there are judges who say, well, that's silly. We live in a world system. There's interconnectivity. Doesn't mean that we have to be driven by these comparisons, but they're relevant. Same is true for states. From my way of thinking, and by the way, let me give you another of these examples. The best one, my favorite one, comes from Shelby County versus Holder, right? The Chief Justice of the United States, to this day, and since we're in Massachusetts, I got to bring it up. So he talks about how Section 5 designates certain states for special protections and doesn't designate others. And his goal is clearly to say, well, this is a silly comparison. You're giving us a rule that doesn't show that the states that are covered are fundamentally different from the states that aren't covered. And let me show you an example, he says. The state of Mississippi has a higher rate of registration among African Americans than the state of Massachusetts. Of course, I know it's a commonwealth, but that's what he said. And you look at that and you're like, oh my God, right? That's a comparison that shows the fallacy of the designation of states that are covered by Section 5 and states that are not, right? But of course, those are two politically different systems, right? One's a heavily Democratic state and has been for a while. One's a Republican state. Now, that may not do anything for you. Here's one that might. The comparison that's relevant under Section 5 was the consideration of discrimination and the way in which it plays out in the political process, such that it fences out opportunity for African Americans. Well, here's a comparator. What he didn't tell you, the Chief Justice, was that the state of Massachusetts has elected 2 African Americans statewide, one Democrat and one Republican, since the 1960s. You know how many African Americans were elected in the state of Mississippi since the 1960s? I'll do you one better, since Reconstruction. Yes, ma'am? 0. Now, if we're thinking about a measure that's relevant, that might be one of them. But of course, how we weight and assess the comparisons, I think, will be crucial. But the challenge, I think, in your answer is, in the question, in my answer to it is, it's not clear to me what the best way of thinking about these maps are compared to others. But I do know that it's not irrelevant for us to think about this in a sort of cluster of all different maps that have ever been drawn. But then the question then becomes, okay, so what does that tell us? Let's say we find that it is, let's say, in the top tier of, on the measure you described, the efficiency gap, on the top tier of measures that show that there's something amiss here, right? Well, okay, we still are left with a hard question, aren't we? Which is to say, well, what's the remedy to this? If we're coming up with a standard, assuming that we get to the point where we say that there's something problematic about Wisconsin's maps, do we get to the point where we can say as a court, all right, if this is problematic, where's the line that we draw? Where are we going to tell states that it is or isn't appropriate? And that's really where you fall back to and I love it, the special cheese plate point, right? On some level, all of this has to be driven by our local context, because we're telling a legislature, right, how to do its work. And that's going to be based on a number of specific things that have to do with the procedures, with the culture that exists in the state, with the regional variation within the state, right? It's not obvious to me that there's going to be one-size-fits-all standard about this, but it doesn't at the same time mean that you take none of this stuff into account, where you're looking at interstate comparisons as being relevant material. It's just how you think about the relevance. I think that's worthwhile. And again, that gives lawyers more to argue over. Yes, ma'am. I'll work my way backwards. Yes.
Have minority majority.
Right.
You're trying to draw for begin to draw in districts and solve the problem. Speak to voter suppression.
Okay, sure.
The district, but everybody's suppressed.
Okay, so you've raised another problem that's not totally distinct, but it's to some degree related, the question of voter suppression. So what do we do when we draw districts to take account of questions of suppression? And it's a very important question. And I'll just say a couple of things are true. One, sometimes people will draw districts with the intention that they know who's going to show up and vote, right? We're all drawing districts to make sure that we've achieved population equality. What we sometimes do, under the radar, is think about, well, all right, do we have people here who just are what some people have described as filler people? They get us the number that we want to get to, but they aren't necessarily people who we think are going to actively show up and vote. So I'll tell you what, and that this doesn't betray a confidence, what most politicians don't want in their districts, not all, but most don't want in their districts, they don't want a university in their district. Right? They don't, and it's for a variety of reasons, just to be clear. This isn't a Democratic or a Republican thing too, by the way, right? Some people don't want colleges in their districts because, well, geez, these guys are seasonal, right? They come and they go. If I have a district that happens to have a special election, and if it's December, as in Alabama soon, my college people may not even show up to vote for me. And then on the other hand, you have who's to say that one of these youngsters doesn't graduate and decides to challenge me, right? They become the college person for the alums in the area and also enrolled students to run against me, and I don't want any of that. That's just one example. The other example is another kind of institution, a prison. I know you've heard probably some about that, I take it. So all of this becomes really a challenge when you think about the extent to which, and that's just sort of built-in kinds of suppression. I think what you might be asking about, and if I'm wrong, just tell me I'm wrong, is the extra effort that sometimes people will go to adopt new rules to make it more likely that their friends and not their enemies show up to vote. So one of the things, and this I guess takes us back to the state of North Carolina, one of the first things that the legislature elected after its unconstitutional plan was put into place, the first thing they did was to adopt this omnibus legislation that fundamentally changed the election system. And they did it to basically entrench themselves, right? I shouldn't say right, I'm going to tell you in ways that they were right. The voter ID rule is one in particular, and in fact, the courts have found it to be intentionally discriminatory. Now, this takes us to voter ID. I know that it is a complicated matter and people differ about it. I'm going to tell you why I don't think we should differ about one fundamental feature. Those who like voter ID are going to find this to be a happy point. I have worked in a number of countries, and most countries have some form of ID. I spent a lot of time in South Africa, worked for the courts there. South Africa has a voter ID rule. New democracy, we herald it as a way in which people can be, fully participatory. They've got a voter ID. And so there's some intuition, I think, on most of the public's part, that, well, what's wrong with having an ID to say that you are who you say you are? Fine. From my perspective, this is my opinion. What I don't like, and what none of us should really like, is the way in which we choose to make that ID a pick and choose method so that your friends have it easy and your enemies, or let's say people you don't know, have it hard. Let me tell you what I mean. Just to take an example, the North Carolina system chose to privilege anybody that had a gun license, which has a picture ID issued by a state agency, as complicit with the rule that gave you access to vote, right? You got one of those, you're good to go. If you have a college ID from a state institution, that is not permitted. State institution, photo on there, you're not good to go. Those are two state agencies that issue an ID. To me, that is selective in a way that's pernicious. And we know in the case of North Carolina, they actually knew what the implications would be. They went and found out who had the IDs that they wanted to privilege, and they privileged them. I liken this to an example that you'll hear, and this is my other hobby horse. You'll hear, well, wait a minute, you need an ID to go into the airport security. Why should you not have it to go cast a vote? That's totally the wrong point, and I get so sick of hearing it. First, my colleagues have said, actually, that's not true. You can go in without an ID as long as you have some other form of indicating that you are who you say you are. I've had people do it. I've not done it myself. But actually, that's not even the model that you should be thinking about when addressing the problem I just described. Here's the problem, and it's an airport scenario. I send all of my friends to TSA pre-check Everybody else, you get in that long line. You take your shoes off, you pull out your computer, take your belt off, get, the extra pat down and, loved up that the TSA sometimes likes to do. That has some practical consequences. But no, everybody gets through, right? But suppose you just had a flat tire, or you woke up a little late, or, you've got the kid and the kid was crying a little bit and you just need a little time to kind of make sure that they were going to be calm before going on the plane. You each have 30 minutes to get through TSA. What do? Well, if you TSA pre-check, chances are pretty good. You might make it, you might not, but there's a shot. But if you are in that long line, there's really little or no hope for you. In fact, you may just decide not to take the flight that day. And that, to me, is exactly what the selectivity of voter ID does. So if you add that to the mix of what a redistricting map can do, it's really one of the challenges of how, in my view, judges don't do enough of trying to cut this off at the start. So you'll find that a lot of judges are given the opportunity to ask to either stay the adoption of the map or rule quickly, and in most cases they don't. In fact, so far I don't know that we've seen one that has enjoined a map from its inception in this cycle. And again, part of the reason is they don't want to stop an election. They don't want to be viewed as partisan. But the practical consequence is, as in North Carolina, we're now getting a point where the state of North Carolina has to redraw its maps. In 2017, that claim started in about 2012 or 2011. Alabama, similarly, just finished the draw of its map in 2017. The court hasn't even ruled on whether that draw is permissible. We've got time for 2 more elections. The next election is in 2018. All those things matter. So it's there's definitely a connection between suppression, and that's just one way in which it's true. But talk to me more about polling places. That's a whole different administrative hassle. But it's a big question. Yes, ma'am. And I'll work my way there, Pat.
Thank you very much. I've got a question for you and for everyone else in the room with all different backgrounds and stuff. But I'd like to hear your thoughts from several people. And from a totally different topic. It's on the question of how to talk about competition in one of these cases. It's a theme that's come up throughout the conference, especially throughout today. So when we heard yesterday from Lincoln Show, and there are several other teams also that are running processes to generate maps and use those to compare, either to compare against a given map or as possibly as alternatives to a given map. And I want to also ask a nomenclature question about that first, for starters. I think that those have been called simulations, and I think that's a disastrous choice of term, from my understanding of how that would fit within legal thinking and legal framework. And also, that's not a very descriptive term for what they're actually doing. Other possible terms might be sampling, exploring. I think randomizing is a bad choice. It doesn't sound very rigorous. I'm interested to hear that from all the different people with different backgrounds, the educators as well, especially when thinking about communication in different ways. What are some ways of talking about the use of automation, the use of algorithms that make some intuitive sense as a good baseline or comparison point, and that makes some legal sense?
Big question, which is why you asked it. I'll give you my initial thoughts, and I would love to hear what other people think too, but I'll just point this out about audience. I think that's crucial. Obviously, right, in the academic world, we usually are talking to each other, and we do adopt, right, terms of art that we readily understand, and we don't have to kind of take several steps to get to before we actually get to the thing we really want to talk about. There are two, in my view, sometimes competing audiences that in redistricting world that I think we have to be mindful of. And this is actually one challenge I'll talk about tomorrow as well. Because we aren't, so our inclination is to sort of stick to that, the nomenclature, the sort of terms as we kind of build towards the point we really want to make. And it can sometimes, as much as it is legitimizing in academic world, it can be distancing in others, or confusing, really. And the two audiences are, one, obviously the courts, those folks that you're trying to persuade to do something, who are disinclined to do stuff in this area particularly that would radically upset what they might see as a legitimate election process. But two, and I guess this is a core area, really, as I said earlier, it's the people. Because ultimately what you want is, what I think we all want is a better educated, a more informed, and I think a more savvy public. And by savvy, I mean not that the public is, not skilled to do these things. They just haven't had the opportunity to do these things before. What we need to do is provide tools and words that kind of hit all the areas that they need to hit in order to make the point that they want to make, which is we want districts that represent us. And so when you mentioned the example of simulations, and I missed Wendy's talk yesterday, unfortunately, but I think the thing that moves the needle for most of these processes that I've described today are that they reflect public will. And to the extent that you want the public engaged with it, you're right. Something that shows the public what something actually means, as opposed to a name that we just happen to randomly give it, is helpful. And if we can put public investment in those things, whether, let's say if it's a simulation, what does the simulation actually represent? That is, what is it that it's trying to enhance, or whom is to benefit from the simulation, as it were? If we give it that name, or that particular iteration of a map drawing process, it, I think, permits more people to feel like they can invest in it, they own a piece of it, because otherwise it is just a group of people talking about a theory that could be something that's good, could be something that's bad, we don't know. We, the average public, I think, don't know. But I think it's probably worth hearing other thoughts about it. But the main thing I would say right now is audience is crucial. And for me, I would prioritize, even over the courts, the ability of the average person, particularly young people, to feel invested in some of these. But I'd love to hear more thoughts about names. Yeah.
First, hi to my former colleague, Nancy Chin at NC Law. But you're good for that. The thought I have is a demonstration plan, which is established for this area. And except Wendy's generating 1 billion demonstration plans. Right? So, the other
generator.
or proof of concept, which was very effective for Ed Felton in the Microsoft case. He used that as a mantra. He basically wanted to show that the operating system and the browser were separable. What he actually did was go and insert a line of code to bypass all the instruction launch in the browser. Obviously, that's not an approach Microsoft would use if it were producing a separate product for the market, but it was a proof of concept that they could afford it.
The word that comes to my mind is validation.
Say more
I
about
think in
that.
software engineering terms, there's a software engineering term it's confirming in some way that you've done some kind of comparison of the map that's on the table with other maps. You validated that it has a certain set of criteria.
So you call the alternate map or what, and you call software or what?
I see. Well, I can sort of throw it out in the room, but I'm saying the model was validating the map with the model. Or the model was validating. I'm not so sure I like the word model either, because it comes along with it sort of, like sitting at my desk building little platforms.
Well, then it's really basic, but the alternative plan, there's an impossible plan. Yeah, those are even in this software, the software, alternative generator. Alternative map generator.
Validation engine.
I don't have a good suggestion for the word, but I actually want to caution. I know you're asking us important, but the case law on the admissibility of multiple alternatives that may have been considered is really weird and complicated, and mostly is derived from medical cases where someone may have looked at a bunch of different tests and only picked the one that told the story. Like, yes, they were affected by this chemical or not. So there's a lot of protections to deny evidence that may have been selectively chosen by one side, which is really bad if you generated a billion tests, because what that means is you're setting up a challenge. So whatever you call it, one of the really important, we can get into this tomorrow, but one of the important things is to represent it in a way that the court understands that this is not being used as a mechanism to hide the results.
That's one of the things, just really quick, why, that's one of the upsides of having an interest supported now, because it reflects a certain set of interest, as opposed to, but there's useful work to be done in the sort of generation that you say the simulations of whatever, a billion or so, just to show the extent to which something that the legislature did is a rate. That's also there.
Quick question to follow up with the whole room. If it were to be called either simulator or sampler, my feeling is a sampler would fly better, but I'd like to know what y'all think. Can I just get a vote on that? Would you lend more faith to simulations? Raise your hand for simulations. And then how about for samples? Okay, great.
I'd rather highly retrained in a flight simulator than a flight sim.
On how well you can show that it's a genuine sampler. So I think sampler is a more compelling word, but you would have to have, from my perspective, a pretty strong reliable case that you were genuinely sampling the space. And so if you didn't have that case, then I would think the word simulator would be more appropriate.
But I think that the everyday language of the interest-free part that somebody brought up would be really important, because while we think about space and sampling and all that kind of stuff, I think really we're trying to get across the fact that there's no interest that's tied to it yet. In terms of we're thinking about all of the possible, right? Before we get to the point of now we've loaded it, and we have the people that are ready to care about.
Yeah, right. It's sort of like looking at the neutral part.
Oh, I'm sorry, so just coming back.
Yeah, so I don't work in gerrymandering, but I work in a adjacent field of explaining technology to policymakers and lawyers and the public. And I think it's important to keep in mind the audience thing, specifically because the language you want to use is going to be different. Like you might want to establish an official name that's going to be filed with the court documentation and have the academic paper that explains it, but you're going to have to take it to, at least 2 levels of abstraction higher, both for advocacy groups who are then going to explain that to the public, because you're probably, like the technical community probably is not doing the direct explanations to the public. So they sort of one step up, that's a little bit a detailed explanation, but not the highly technical one, and then they can also help translate that into terms and communication materials that speak to their community. They can say, this gives you, lets you get one person's vote, or whether it's a community representation or something like that. So just recognizing that there are multiple layers of communication that are going to be needed.
And I should say, get to this question just next. That was one of the most fulfilling experiences I ever had, was to work with software designers and do like multi-platform work on a number of areas, and we created a platform about redistricting. And the hardest thing was the very thing you described, which was all right, what is it that you want the user, A, take away from this? But what is it that you want to have them understand just in terms of the tools and play in the game, as it were? And, if you get down to the elementals of that, you really do kind of figure out exactly what makes this thing go. And really what makes, a tool like the one you're describing most effective. I was just also thinking that you all talked about the word universal or universality. You really want to look at the entire array of options available.
That would be challenging. I know it would. I know that as an everyday word, I think it's people would understand.
I like it. Straightforward.
Yes, I think what people understand, we step away from the math-centric community that we're now. I think simulation has the implication of needed process, but on the street, when someone thinks sample, they think 3 samples and they get that one time.
Yeah.
Not the civilians of our brain.
No, like the civilians watching the news, the civilians that are the majority of people who don't know that a sample is made up of multiple generations in a simulation. I hope again off the simulation applies to some and all less possible.
I see hand in the back and I'll work forwards. Let's say I'll take two gentlemen at the back. First one. Yes.
So I think Wendy's presentation was phenomenal, and I think I would vote for simulation. The problem I have is that for the mathematicians, Wendy's computational strategy assumes non-separable preferences. It assumes that the preference for compactness does not have an impact on the preference for contiguity or partisanship, right? So they're all unidimensional, right? But in political science, we know that there are non-separable preferences. So you got guns and butter, right? So how much domestic spending you want is a function of how much you think you want foreign spending, right? So in the Bartlett case specifically, the reason why blacks were articulating, okay, look, we know if we get a white representative, there may be advantages to having a white legislator that they may not have for black legislators, right? That's the reason in Georgia v. Ashcroft, the black legislators walked away from passage because they understand maximization as a strategy didn't work in the 1990s. And so the Democrats figured out that if you pack black Democrats, or you pack Democrats, you pack black voters, right? So if you're gonna think about the next iteration of what we do, think about the fact that there are voters on the ground who have preferences that are conjoined. They understand that if a bunch of Democrats are packed, then that means most likely they're going to be black voters, right? So, I mean, we've learned from Dulac, we've learned from Charlie Reel, we've learned from all these cases that the legislators on the ground understand that there are non-separable preferences. So if we're going to do computational strategies, we need to think about the connection between the preferences and then how does that generate a map.
There's a lot to say, but I have one more question. I take the quantitative analysis point, but I'm curious, I'd love to hear more about your take on Georgia versus Ashcroft in those cases. I would just say simply, legislative preferences, or what legislators learn from a particular iteration is sometimes more contested than you would think. But yeah, I'll go to this next step.
So I'm curious, you mentioned desire for, or your preference for judges stepping in early rather than late. So if you can show results or quantitative measures that are based on the results of elections, you're kind of late, right, in the process. You're showing evidence of harm after the harm has occurred, and you prefer, or at least you at least like a space where you can apply early. And it seems early would require some demonstration of intent, right? Or is that true? Or that's my question actually. What to participate, right? You said judges are wary of doing so. So what would be a compelling? We've talked about measures, but during history, talk about kind of those metrics and stuff. I'm sort of interested in how you would make the argument that intent is here. Because if you show alternatives, it's an alternative. Like, I mean, the more alternatives you show, well, the space is hard. You need a supercomputer to run it. Like, we just had, four people in a room. Like, sorry, we didn't do quite so well. We tried. But, like, what would cross the threshold in your experience and opinion to showing intent? Suppose I can say, a group really mapped this line always shows up, but in this map it didn't. I know it doesn't exist, so that's hypothetical, but I mean, it seems you need to cross an intent line if you want early action. You need to cross some line. Maybe it's not intent, but intent would be one of them. And I'd be curious what you think about other lines might be, or how you might get there.
So I'll be brief and I can say more about it, but so the first point to mention is I don't think that an intentional case is the only case that one can make to block a redistricting plan. So that gets me part of the way in saying, well, it's not necessary that, I have to have a person on the record saying, I'm going to screw this group over because they're this group, whatever the group is. But it does then raise another problem. The problem is, well, if I'm not showing intent, what is it that I can show in the likely effects of a map that creates some sort of problem, right? Whether it's a partisan gerrymandering problem, a race discrimination problem, etc. And the problem there actually gets to the point that you started with about courts. One of the reasons courts are
concerned about getting involved is, well, nobody has a crystal ball, nobody plays Karnak the Magnificent. They don't know what the likely outcomes will be absent an extreme case, right? And you're going to always have the state on the other side saying, well, who knows what can happen, right? And in that place of uncertainty, the courts are loath to want to get engaged. Couple points. First, to the extent that the court decides it will not get involved at the outset, right, and it is using a somewhat extraordinary remedy to enjoin a map from being engaged, if you're going to do that, then the cost is going to be on doing the litigative work to actually get to an answer that it is invalid. It seems to me a stronger and not a weaker argument at the back end to say, all right, we're going to correct the map now, we're going to draw it, and we're going to have a special election. You don't get courts doing that at all. It is a hard thing to get the court to say, even at the back end, even if it is found discrimination, even of an intentional variety, to require a special election. That's what the state of North Carolina has just discovered, at least the Democrats in North Carolina are sad to discover right now. So what does that leave us with? Well, it seems to me that if the costs are going to be borne on all of us, whether it's in money and time and all the bad laws that get on the books due to a legislature that's benefited from an illegal map, the only answer to me is to offer a remedy at the outset. Well, how do we do it? This is one of the reasons why I think some of the criteria being articulated early, the Florida example is a pretty good one, where you've got the court at the outset giving its iteration of what it thinks matches the compliance with each one of these considerations when it's reviewing a map in the outset. We don't really have that right now in most other states. California has a version of it, right? You get a fast track to go to the court if you choose to challenge the map that the independent commission has drawn. But it gives you, at least at the outset, some limited review of the map and some record through which, even if you don't win there, you can go to federal court or whatever on another claim, and you have the state locked into a story. So to me, that is definitely imperfect. It doesn't give you much traction unless you get a lot of evidence early on that the state is playing a game that's somewhat inconsistent, or you've got the smoking gun, right? As you sort of uncover a few of the emails back and forth. It happens more often than you think. But you're right, it does present nonetheless a really hard problem, particularly in those cases where you don't have agreed upon criteria that are sort of derived before Legislature A gets control. Because Legislature A, I guarantee you, will think very carefully about the map that it wants before telling you what the criteria are going to be that inform how it's going to draw the maps. Or put another way, how they've already drawn the maps and you're just going to be led in through a process about how they are to be drawn. That's not every legislature, but a lot of them. There was a hand down here. Yes, sir. Sorry. Yes, please. Sorry. Yes, ma'am.
One comment and a question. As far as like the name, what I heard is 2 different points. And you might be trying to get both. But one is a question of function. Do you want to explain the function of it? Or do you want to convey the feeling of it and the value? And that might kind of dictate which way you go. You can do both. But if you want to do one or the other, then I don't think it matters if you call it a simulator or sampler, if what you're saying is functional. But if there's an inherent value or intent behind the name, then I think there's more that needs to be explored there, like what is the value, what is the feeling behind the name that maybe you want to convey.
I'm worried about like big movie traps I don't know about, for instance. I think we've heard justices say in the past that they mistrust speculative. And I'm worried the simulation sounds things like that also. So that neither is actually functional. You know what I mean? But either.
Well, I'm in a communication, and my only comment to that is sampling, like asking, preferably people that aren't doing what you're doing, get a better idea of the
Sample to ask feel like sample.
Right. Yeah.
These are the conversations academics love.
And my question to you is, I'm from Colorado, and we have a 35% unaffiliated majority. How do you see that impact multi-party situation? Because we're trying to get that voice more present in redistricting. What's your take on the role and affiliated vote?
Well, they play a huge role, and one of the challenges, obviously, is when, at least in partisan world, we are sort of dealing with two tracks. We're forcing everybody through, a system that doesn't necessarily reflect either people who are, third-party supporters or independent, unaffiliated voters. And in a state like North Carolina, Colorado, where both you've got, right, a significant sort of non-majority party viewpoint. In fact, there is no majority party if it's 35%. But where you've got none of the traditional parties sort of defining affiliation for most people, and right, a system that actually makes it possible more often for people to participate. Right, if you've got a vote by mail system, right, you make it more likely that regardless of your party affiliation, you're likely to engage in the political process. It's important. So my general thinking about this is, I don't know, I have to say I have not had any projects in Colorado, but my view is, I know there is a pretty strong level of support from people I've just talked to about it for moving towards a more independent, totally insulated process of drawing districts. And one of the reasons for advocating it obviously would be thinking about things beyond party, to move it even farther away from the typical Democrat and Republican arguments. Washington talks about that as Washington State has a consideration, a few other states too, about looking at competition, not party competition, but competition as some measure of whether or not a district is drawn fairly with a small f. And they think the more competition there is, the fairer it is. So they won't let a district go, over 60% for one party. That's at least their aspiration. And you could imagine how more complicated but interesting that could be in a place where just looking at Democrats and Republicans doesn't quite do the trick. I don't know quite how I don't know how organized right now the unaffiliated voters are, or the third-party voters are, around the question about independent redistricting commissions, and again, further insulating it from the process. But it strikes me that one big upside for that is that you get more people able to articulate what community looks like. And if your community makes it more likely that a candidate can do better in, let's say, a run for Congress, which is usually one that drives, right, normal two-party competition, you make it more likely in a district that you can get, I think, less partisans, hard partisans in a district. You get it more likely, I think, a strong, well-funded candidate who doesn't happen to have a DRR behind their name, at least with a fair and decent shot at winning an election. So, I mean, those are at least just some initial thoughts in terms of structure. Changing fundamentally the way in which district lines are drawn might be more likely in a place where you have D's and R's not totally driving the process.
So do you see that as one strategy for states to start breaking up the two-party system is to register as an affiliate?
Well, that's an interesting possibility. I hadn't thought about that at length. Not every state has registration by party, so that's one important part. But in places where there is such a thing, it does make it a little bit more challenging to identify the partisan affiliations of a particular community. On the other hand, I will tell you, while I may not have registration data on you, I have a lot of other stuff that helps me get a derivation of where your leanings are. And this becomes a problem, right? It's hard to know how to chip away at the iceberg if you're really wanting to dismantle the DNR debate, because we've gotten so sophisticated, right, where we now know based on the detergent you use or the car you drive, what you're likely, even if you don't have a DRR behind your name, what your likely affiliation will be. And that becomes relevant for whatever the district lines are that we're going to draw. But still, despite all of that, you got to start somewhere. And the extent to which you can get, it seems to me, lines that reflect competition for everybody gives you the chance to elect, certainly at the state legislative level, more people who look beyond the Democrats and Republicans as a means for representation. Or at least maybe Democrats and Republicans who see right, unaffiliated voters and third-party voters as allies and not enemies. Okay, so I'll start back on this side here and work my way back. How about the lady in the back with your hand up? Yes, you with the wristband. Yes, ma'am.
Okay, so right now we're all pretty excited about the Whitford case, and that there's like massive stats in there. And if we recall from 10 years ago, when the state set up their various guidelines, many of them were, in my opinion, at least pretty misguided about like advice about how we can get involved now, helping as a hero for the next in particular, terms of providing advice to secretaries of state and so on?
Really good question. In some ways, I'm not even sure right this minute, with respect to redistricting, that secretaries of state are necessarily the people to put pressure on. But let me suggest at least two ways in which. Okay, and that's all fair. I was just thinking through. Of the rank order. We've only got a certain amount of time, but that definitely is certainly a group that you want to be in touch with respect to voter suppression questions. But with respect to guidelines, I mean, that to me, a lot of this is the ball game. I'll just give you an example. The state of Alabama leads first on this, not on many things, but on this. They're first, or right at the top, with utilizing a very stringent level of, and now I'm having a mind freeze. Sorry, I was on an international flight yesterday. Population deviation. The band of population deviation is one of the tightest in the nation at the state legislative level, right? Those of you who do this know that at the federal level, the court applies a very exacting standard, as near as perfect as you can get, practically speaking. At the state level, there's more latitude given. Alabama chose a plus or minus 1% deviation. Now, this was not Alabama listening to the best, experts that say, it's possible to do it. There are all these benefits to do it that are, population enhancing, et cetera. This was, and you'll see, there are only about 5 states in the union that chose something like that. That isn't a standard written in their constitution. All 5 happen to be under some form of litigation involving racial gerrymandering, right? To the extent that you can narrow the scope of what a state might do in terms of enhancing representation for any group or privileging a region, right? You've narrowed the sense of possibility, right? And Alabama chose to do that. Now, did they have to contend with a group of people that said, statistically this makes no sense? And in fact, the consequence of doing that narrows our options to the following 2 or 3 things. That didn't really occur to anybody until after the fact. Not occurred to me, but I'm an academic doing 5 or 6 other things right now, and they aren't necessarily interested in what I have to say. But more important, the public didn't know. And by the time we got to the point where we're drawing lines, the answer is, well, we've already chosen the standard. There's nothing else that we can do. There are plenty of other examples like that. Where you put a voting tabulation district, I don't know if we talked about that yet. Has that come up? It's one of the sleeper issues that are out there. Voter tabulation district essentially is a precinct, not quite, but we'll treat them as the same. The place where we go and vote. It's the analytical unit for most of, not all of, but a lot of what the census does. But the voter tabulation district is an administrative space that's decided on by a county. And it's either a probate judge or a county supervisor, somebody like that you should never see, right, until something goes wrong. Well, a voter tabulation district can be, going back to the guidelines, one of these rules that the state legislature will adopt, which will say, we won't split a voter tabulation district. Well, why not? If you actually looked at these things, they change arbitrarily from time to time. They are varied in their population sizes. So if we can't split them sometimes, it interferes with our ability to create roughly equal districts. But you'll see not only state legislatures, but the courts will say, we are making sure that we're constraining bad behavior by saying, don't destroy voter tabulation districts. Well, okay, that sounds nice in theory, but do we know that that actually operates that way in practice? And to be clear, states will differ about their practice of using voter tabulation districts. Some will only change it at the time of the census. Some will change them willy-nilly. But whether or not the deciding party that looks at the guidelines is thinking about that and what the consequences are of that, or what the alternative approaches would be. And I think those are things that I think the community that you've described can be really helpful in developing. And just sort of simulating, if you will, the likely consequences of another option to the public helps us have the debate before we actually get to the substantive debate about these things, because they matter greatly. So I think that would be tremendous. But there are a couple of others. I'm happy to talk to you afterwards about a few other examples, but I love that you're thinking about this now. Let's see. Oh boy, I hadn't seen you guys yet. This gentleman here, and then I'm going to work my way back and come forward. The gentleman is in the blue, the dark blue. I haven't heard from him yet.
So we're talking a lot about visibility of state measures for gerrymandering detection that are areas
tell me a little bit more, I might have missed this. The black box idea is.
So, for example, Lenny's topic I was mentioning is she does computer science research generating relationships and other characters. That's really obvious. How do course speak about that sort of thing?
Depends upon the context in which it's raised. So again, the example that I think becomes most effective for that kind of thinking comes when the party presenting it is trying to say, the thing that they chose to do is really aberrant, right? Don't look at this as like, oh yeah, you would have naturally come up with this. So that's kind of the easiest case. The challenge then is, I think, the case where you don't really have a really bizarre case, right? It's the case that, kind of sits right in the middle. And also maybe, and this may be where you're gesturing toward, I don't know, if you're trying to convince the court that a particular consideration ought to be something that they should prioritize, right? Let's say we've got a kitchen sink that's listed, but no prioritized list for them. You could imagine, right, you do a black box simulation and you figure, look, you choose this one thing, you put this at the top of the list, you're more likely to get a good outcome versus a bad one, and good with a small g, bad with a small b, right? It's not obvious that you're going to convince a court, absent some other principled argument, that the fact that, a simulation, let's assume it's a legitimate one and that we all agree to, comes up with that finding, that alone will give them reason to say, all right, and in our directions to how this legislation should fix the maps that we found faulty, you need to prioritize this thing. There needs to be a why to it, I think, that goes beyond just the sort of, well, this is what is essentially the black box has produced. But I think it can be useful. I don't mean to demean it at all. I think there is going to be a limit beyond which many courts, though, will use it in an affirmative sense to derive rules absent some other legal argument. It can be supportive, right? But not on its own, I think, dispositive. All right, I'm going to start at the back and work my way down the ski slope for him. Yes, sir.
I wanted to comment on the naming question that I just wanted to point out and suggest that one of the areas in law where we routinely do not simulate but do sample is in jury selection. So just like there's a jury summons, you might call it a mapping or district summons. Just like there's a jury pool, you might consider that district or mapping pool. The act of telling your sheriff, look, I need some jurors or jury, you call that district area. Just like you voir dire jurors, you voir district or district. That might be for a more jurisprudence target market, not for the general public, but that might be a way to kind of hammer home, because even just some abstract hypothetical juror, like a real person that could legitimately represent a real fact.
I want to make sure I get other people on this side. Yes, sir, in the plaid. Yes, sir.
One of the kind of rubs I see is the sense of kind of like going into a court and saying that statistical methods have a place in thinking about crucial questions in our democracy. Mathematical notion of capacity and how to solve are crucial for people who are democracy. One of the arguments I keep on saying that I must believe has passed away, but I always think that like the archetype of like, the constitutional, like what would the founding fathers confirm? I think it would be very helpful, before we set up this narrative, that we have a pre-narrative where we talk about the role of mathematics and the sciences in economy. We talk about atoms and how we use Newton's second law of forces acting in equal and opposite ways, race both about ambition, checking ambition, and this is why we go through practical problems. We just talk about, the Newtonian framework that Jefferson placed on the Declaration, the term self-evident is extremely deliberate. It's coming from the Enlightenment, the language of Copernicus, and you get to, of course, you have, apportionment, which is directly related to elections, the Hamilton Jefferson debate. I know that I'm still going to say more about this in the educative track. And, there's a lot more results, so, I could talk for a long time. But anyway, there is a narrative there where we can appeal to somebody and say, look, this is not new news. But we need to take, our modern narratives and the modern ways in which we tell stories about mathematics
and do so in a way that's consistent with the way the founding fathers envisioned the development of the law.
Another thing that occurred to me along these lines, the census itself, simple. Maybe helpful. So thank you for your thoughts. Have further thoughts about that specifically would have the question, send them to me or to our director's email address, because I keep thinking about that. These are some of the best people assembled here that I want to
I want to read the chapter of that book. It just sounds like, seriously, I mean, there's a lot I sort of knew a lot about, but a lot more than I did.
Okay, for a reference, well, one thing, one makes references in this written by historian of sciences, written a lot on youth in further form. He was a historian of science here. I want to say maybe somewhere in Boston, maybe Harvard. And then there's oh yeah, it's called Science and Founding Fathers.
I'm feeling guilty for not taking history of science. I think you might have a question.
It was another question, and I don't know if you were just trying to shut that conversation down. But
I could just have 2 more minutes. So to you,
You know what? Why don't we take a couple of questions really briefly stated, and I'll try to respond to them all. How about that? Okay, so we'll take yeah, go ahead.
I think very seriously about this bias room, and one particular thing that I keep going back to is I think random sampling is the thing we want to hear most, and random sampling is the thing anybody outside this room wants to hear least. And it's very, very, very particular, the word random. I think as a lawyer on the other side, I would say it's random. They don't know what they're doing. They have no control over the process. And I say that in particular because there was a totally reasonable misunderstanding during John Luke's talk yesterday, in which somebody said, well, it's random. How can you take anything into account? There are things in my state we need to take into account, and we're doing that. We know that. But people who did not totally understand the process did not see that this was helpful in any way. And so I think that the language that needs to be used has to be one of search, of deep exploration, and as I would call it deep map maker. It's making maps. I think simulation sounds hypothetical. I think generator sounds robotic and inhuman. Map maker and deep, because I think the language needs to explore. We are searching, we are exhaustive, we are responsible, we are looking as hard as we can.
Although I don't know, it sounds like, I don't know, I just learned what the term deep state means, but I like the concept behind it. Let's see, just in case, were there a couple of other questions? If not, we can wrap. Okay, yeah, we'll make this one the last one. Yes, ma'am.
Made it sound a little hopeless that there's no really sort of after the fact, we found a bad map and prove it is bad. Is it truly hopeless? I mean, I understand proactive is obviously great, but is there any remedy in this?
Well, it's not hopeless. I don't mean to suggest that. It's just not costless, right? Which, by that I mean, North Carolina is actually in a very positive space right now. I mean, I talked to them at the beginning of this process in 2012, and I told them it would be a marathon. And I don't know that even I thought how long of a marathon it would be. But they're now at a space where they've got a court that has explicitly told the legislature, you got to redraw these things, and then you have until September 1, and if you don't do it, we're going to do it. That's about as clear as you're ever going to hear a court articulate its view. Now, I wish they had said, and by the way, we're going to have special elections under that map, but whatever. Can't get everything you want. My view in that case, I want to use this as a frame to talk about what I think one can do in these circumstances. The public has been much better educated in North Carolina about this process. When we started this, it was really a conversation with a very few people, a couple of interest groups that were really engaged, but it really took a built coalition, and I can't take much responsibility for it, but a coalition of people who saw what the legislature was doing and saw all the different substantive ramifications of what that legislature, once entrenched, would accomplish on issues ranging from, either, depending on how you feel about it, gun rights to reproductive rights to religious rights to all these issues. And you saw groups that you would have never seen in a conversation about voting rights and gerrymandering out in the streets like this time of year in the heat in North Carolina. Not an easy thing to do.
protesting about this topic. So I think now you've got a coalition of people who are now searching for answers. That is, not just answers to this particular problem, how to get the maps right this time around, but to say, we need an independent redistricting commission. Now that used to be something Republicans liked before they got the majority, right? Democrats hated it, but now they're for it. So what's missing now is, right, that extra little puff to get them across the line to say, all right, everybody's been screwed by this at some point. We need a process that doesn't cost us tons of money. Now add to that what I said earlier. I think it was the price tag I saw just in the last couple of weeks was like $5 million that has gone just to the state's lawyers. And when I helpfully reminded people what I just told you, and by the way, they will actually have to pay the bill of the plaintiffs who won the lawsuit. You can see how a simple approach like an independent commission could do some of the work. So it's not hopeless, but it takes, I think, a broad coalition of people, voters, but also people of different expertise. Because again, I think once you come up with the idea of, hey, let's have an independent commission, then the next question is, well, who gets to choose who they are? And what criteria will they use to draw the districts? And do we want court intervention or not? And that's where you take, right, the principal question to the, all right, we got to actually put a nuts and bolts system together. How do we get that to work? We need to simulate some likely outcomes. We need to figure out what the implications are mathematically of using a band of population differences between the districts. I've now forgotten the phrase once again, short on sleep. But there are all these other considerations that maybe we haven't even talked about yet that we can kind of incorporate into the system. And if we can do all of that, I think we improve ourselves. But that is, unfortunately, right, a long and costly process, but hopefully it's sort of like fighting a war. When you're done with it, hopefully you learn the lessons and build a structure in place to try to prevent it and maybe get ready for the next one, wherever it is. So don't mean it's hopeless, but I do mean it's not costless, I think is the best way to put it. So I think it's probably time to wrap up. Thank you all for your attention. I appreciate it.